Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, as we head into the holiday season, we are always remiss that 2023 is right around the corner, and we are heading for a major war as it relates to defending our Second Amendment rights. We have state legislators all around the country clamoring for new and creative ways to disarm otherwise lawful and responsible citizens, and we know that there is going to be major wars on magazine bans, assault weapon bans, and of course the pistol brace rule set to drop any day now. As we head into 2023, you're going to hear about a lot of litigation, you're going to hear about a lot of rules of law, you're going to hear about a lot of cases and why some of them are good and some of them are bad for you. What I thought we could start doing here as we kind of settle down over the holiday weekend is get into some pretty serious geek out material, start talking about some of the rules of law, get you familiar with it in plain, simple English so you can understand some of the weapons that are going to be used to defend your Second Amendment rights. So today, we're going to spend a few minutes and talk about the beauty of the common use test and why it matters now. Okay, so the issue we're talking about today is the common use test. What the hell is the common use test and how does it benefit you? What exactly is it? Well, the common use test was a test developed by Justice Scalia in the landmark opinion of District of Columbia v. Heller. Now, why was District of Columbia v. Heller such a landmark opinion? Well, first of all, it was decided in 2008, and there hadn't actually been a Second Amendment major issue case before the United States Supreme Court since 1939 in United States v. Miller. The second and most important component, though, of DC v. Heller is that what was being challenged was some crazy gun laws out of the District of Columbia, which included an absolute ban on all handguns, and then if you were even allowed to have a gun, it had to be locked up, secured in a safe, key stored in another location, all kinds of things like that. And then it was virtually impossible for you to carry a firearm anywhere, including inside your home. So when these laws were challenged by Heller and it got all the way to the United States Supreme Court, there were two critical issues in this to be decided. Number one is, what sort of activity does the Second Amendment protect? And then number two, what types of firearms, what types of arms does the Second Amendment protect? And those were the two big issues to be decided. What I want to focus today is on the second part of what Justice Scalia authored in Heller, which is what sorts of arms are protected by the Second Amendment, because that is where we develop the common use test, and that's where we're going to see its applicability to current day legislation such as, AR bans, semi-automatic weapon bans, magazine bans, and many of the other crazy gun-grabbing legislation that we're seeing statewide right now. Okay, so when Justice Scalia engaged in this long analysis, and it is a long opinion about what sort of activity does the Second Amendment protect, and then what sort of weapons and arms does the Second Amendment protect, when he began to take a look at what sorts of arms, he basically said, hey, listen, we take a look at what the text of the Second Amendment means, and it basically means that we get to keep and bear arms. However, he said that we also need to take a look at our historical traditions to see what sorts of gun control legislation has been permissible throughout society in American times. So a kind of a short way of looking at it is Justice Scalia said, hey, listen, the Second Amendment gives us the right, and history has the potential of limiting that right to some degree. So like the text will give you the right, and history can take some of that right away. All right, now, when Justice Scalia went and did this long historical analysis, and it is long and it takes up many, many pages of this opinion. However, when he did it, he came to one inescapable conclusion. And that one inescapable conclusion is that the only types of arms which traditionally have been permitted to be banned in the United States, going all the way back to colonial times, pre-adoption of our Constitution, were weapons which were deemed both dangerous and unusual. Okay, let me say that again. The only types of weapons which traditionally have been permitted to be banned are weapons which are deemed both dangerous and unusual. Now, those on the gun-grabbing left have tried to reframe that argument as dangerous or unusual. And candidly, I think we can agree that all weapons, especially in the wrong hands, are dangerous, okay? But it is not a disjunctive test, okay? It is a conjunctive test. And so the court has clearly said that, listen, unless the firearm is deemed both dangerous and unusual, any ban of that weapon is per se unconstitutional. So how does that apply to, I don't know, let's take a semi-automatic rifle ban? Well, the only type of ban that it has a chance, a snowball's chance in hell of surviving a constitutional challenge is a ban on a weapon which is dangerous and unusual. However, in order to be unusual, it would have to be a weapon that's not particularly ordinary, right? Not one that's in high circulation. And when we get to semi-automatic rifles, primarily in the AR platform, it is by far, without a doubt, the most common rifle in circulation and one of the most common weapons used throughout the entire nation for many lawful purposes, including self-defense. When we take a look at magazine bans that are happening nationwide, like my folks here in Washington State are already dealing with, and the folks in Oregon are going to start dealing with, and some people around the country have been dealing with for years, okay? These are not high-capacity magazines. These are standard capacity magazines that come with firearms that are in common circulation everywhere, in every corner of the country, used for many, many lawful purposes, primarily defense of oneself. When we take a look at House Resolution 1808, which has actually passed out of the United States House of Representatives and is before the United States Senate, a piece of legislation which actually bans damn near every semi-automatic firearm in America. How can that firearm be deemed unusual? So, the bottom line is, the point that I am trying to make is that the common use test is one of the most critical weapons that we will have in this upcoming year to fight to preserve our Second Amendment rights. The common use test basically says, listen, if the firearm is the type of firearm which is in common circulation today, being used for lawful purposes, only one of which has to be self-defense, then it is the type of firearm that cannot and will not be banned. Listen, we will be doing another couple of videos in this kind of geek session here, one on the Bruin opinion, the other one, a really important one on the protections afforded us through the Firearm Owners Protection Act. In the meantime, if you have any questions about this or anything else related to your Second Amendment rights, remember, you can always contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. Now, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.